If we don't finish, we'll pick up when we can, but we've got everyone, so we might as well start, and we'll see where we go. Okay. Mr. Marriott, let me get you out of the breakout room. All right, Mr. Marriott, can you hear me?
Yes, sir.
Great. You're back in the main courtroom. I'm going to add you to the screen, your lawyer, and the prosecutor. So we've got all the folks here. We're going to get on the record. This is 25 SC 003 438. And it's Damari Marriott, supposed to be here in court today. We had a little transport hiccup, so he's appearing virtually from the jail. And one of his lawyers, Mr. Howell, is here covering for Mr. Apt. Mr. Apt has a conflict as well. And Mr. Apt had filed a bond motion, so we're going to start our discussion about bond and see where we get. Mr. Howell, what do you want to tell me about your client and his fit for bond?
Your Honor, Mr. Marriott is 20 years old. He was arrested April 10th, 2025. He is a lifelong resident of Georgia prior to his recent move to Florida. He moved down to Florida in 2024 in order to get his GED and meet his grandmother and start a new lifetime there. If released, he could live with his father in Powder Springs. He has numerous aunts and uncles here in Georgia. His father is here today, and he has committed to ensuring his son does not abscond or otherwise follows all orders of the court. His previous employment history, he is young, he is only 12 years old, but prior to his move to Florida, he had worked as a warehouse worker. He had worked at Wendy's in 2024, and then prior to that, had numerous jobs in and around the Atlanta area. He has numerous ties to the community, again, through his family and his very long-term residence here in the Atlanta area, where he attended high school, I believe, the next.
What high school?
Hillgrove.
Okay. Where was Hillgrove High School, Mr. Marriott?
It was in Powder Springs, sir.
Okay. Do you have any kids, Mr. Marriott?
No, sir.
And it's your grandmother who's down in Cutler Bay?
Yes, sir.
All right. We do have someone from pretrial on the call. Do you have any criminal history information on Mr. Marriott?
No, sir. I only got locked up.
Oh, I'm sorry. I'm not asking you, Mr. Marriott. I'm going to hear from the person from pretrial.
2 cycles. Can you hear me?
Yes, sir.
2 cycles, no felony convictions.
Got it. Thank you. All right. Mr. Hiles.
Computer just. So, Your Honor, I do recognize that the defendant does not have hardly a criminal history at all. However, Your Honor, the facts in this case are overwhelming, and let me lay out a little bit of what's going on here. So,
I'm going to interrupt you for a quick second. I just want to confirm, Mr. Howell, you don't have any discovery, and that's not a knock on anyone. You are hitting this case about as cold as can be. One, not your case, is Mr. Apt's, but I think we're early enough in this process. While Mr. Apt has opted in and waived arraignment, no discovery that you're aware of has changed hands.
Correct. And just to preface what I believe we're about to hear, I would object to anything that doesn't go to the Ayala factors. I believe what the state's going to go into is probably more relying on, well, this is a slam dunk case, or this is the strength of the evidence. And I don't believe that's relevant in this type of hearing. It may be relevant in the civil type of preliminary injunction hearing. Ayala is not for pretrial punishment.
Okay, no, I appreciate that. And I focus less on strength of case than just some of the allegations in the case so I can make my own determination about risk to the community. So I'm going to let Mr. Hiles share what he wants to share about this, but I'll be mindful that whether it's strong or weak is less of a point than does it seem serious enough that either bond doesn't make sense or it needs to be this size bond versus that size bond. Okay, back to you, Mr. Hiles.
And my counter, thank you for letting me speak. My counter, though, is that likelihood of conviction does go directly to threat to flee when it's a sentence of life.
Okay, I'm going to let you present what you're going to present.
All right, so, Your Honor, Mr. Marriott was friends with the victim in this case, Monty Van Arsdale. They had a falling out sometime in 2023. Mr. Marriott, on multiple occasions, told different individuals, and this is coming from his phone dump and his Instagram extraction, that he plans to, quote, take down Mr. Van Arsdale, the victim in this case. And on December 9th of 2024, Mr. Marriott sends an initial text message to the group of individuals charged on this indictment. Who's looking to take somebody down? I got someone who we can steal his weapons. He then creates a group chat and includes Mr. Van Arsdale on that group chat and says, we're looking to trade some guns. The members that we've alleged to be part of four-way, along with Mr. Van Arsdale, start trading pictures of guns and talking deals. And
it's just Mr. Van Arsdale on one side, so one potential gun trader, and then all these four-way people on the other, or?
So Mr. Marriott creates a group chat that includes himself, Mr. Van Arsdale, as well as all the individuals in four-way.
I followed that, but.
So there is.
So it's sort of 8 people negotiating with one person.
Yes.
Okay, that's what I was getting at.
Yes. And a date and time is set up, but then there is a direct line of communication between Mr. Van Arsdale and Mr. Marriott. And Mr. Van Arsdale is expressing his concerns of driving to Atlanta for people he doesn't know. Throughout that concern,
Mr. Van Arsdale's coming from where?
I think Powder Springs, but on the December 9th, he says he's coming from North Carolina. That's what the message is saying. But he is hesitant. He resides in Powder Springs, is hesitant to come down to inner city Atlanta to buy himself for a weapons deal. All the while, Mr. Marriott is reassuring him that everything is fine. And then he is on the other line of communications, is in a group chat with the four-way members that Mr. Van Arsdale is not a part of, talking about how he's a sweet nerd from Cobb County. He ain't got no street smarts. Don't worry about him doing anything funny. And in that text exchange, it is floated from Jadon Chambliss, what if we just trade weapons? And it is explicit, all caps, I need him taken down, no trades. This particular weapons deal never happens, even though Mr. Marriott is sharing his location, with Mr. Van Arsdale, Mr. Marriott sharing locations with each other, which is simultaneously being sent to the group of four-way members so they can track his movements, where he is getting closer to the city. Mr. Van Arsdale ultimately gets cold feet on December 9th of 2024. Then, same group of individuals with Mr. Marriott initiating the conversations begin to set up a marijuana deal.
With Mr. Van Arsdale?
With Mr. Van Arsdale.
So now it's weed, not guns.
Now it's weed and not guns. Still in one text chain, there's a text chain with Mr. Marriott and the four-way members that Mr. Van Arsdale.
Mr. Van Arsdale would be selling marijuana to the Four Ways?
Yes,
Okay.
he did. That, I mean, he absolutely was agreeing to sell marijuana. He did bring marijuana.
And this is now on the 29th?
This is now on the 29th
Okay.
of 2024. He was given a location off of in the area of Gun Club Road on Washington Street, and lured to the area. All the while, he's still sharing his concerns with Mr. Marriott about dealing with these individuals that he's never dealt before, while Mr. Marriott is encouraging him to go through with the deal, saying it's easy money, nobody's going to try to take you down for this small amount of marijuana. And then again, having a simultaneous conversation about the location, timing, and when the victim's supposed to arrive. When the victim arrives, he is ambushed, gunned down, and his belongings stolen from him. Shortly after the murder takes place, before it has even hit the news, Mr. Marriott calls the Van Arsdale family, specifically Leah Van Arsdale, and says, "Oh, I think Monty's been shot. I know some people that are talking about it. I got to get with the people he was with." And alludes that he has information before the police have even identified the body that was on scene. After he was led on, the Van Arsdale family are able to figure out where the body was transported, and it came to light that he was actually killed. So then there are several Instagram threads that continue days after with the people that were involved, consistently making jokes about the death of Monty Van Arsdale, calling him soft, got what he deserved, he was weak, he was from up north. And then on January 6th of 2025, over Instagram, the defendant is directly confronted by a mutual friend stating, "You're the reason that Monty was killed." And he laughs and says, "Your partner died, now I'm a bitch, okay." And then the response from the friend is essentially, "You were the main reason he died." And the response from Mr. Marriott is, quote, "LOL, I'm the real reason your man's in heaven. If you really think about it, even your partner said you a rookie." Additionally, on January 7th, a direct message was sent to a close family friend of the Van Arsdale, specifically stating, "You need to stop talking or you're going to wind up with Monty."
Direct message from?
It was a direct message from Marriott to the family friend of the Van Arsdale family, which was immediately communicated to the Van Arsdale's family. Speaking with the Van Arsdales, they believe truly that there's no way you could communicate with this individual without the intent of having the family know about it, that close of a family friend. Before he moved to Florida, he was living within a 5-minute drive of the Van Arsdale's family. The Van Arsdale's family had welcomed Mr. Marriott into their home. And all of these actions just show the callousness of the planning and the intent. And I feel that they make him, one, a danger to society, a threat to intimidate witnesses, and also the fact that he has moved to southern Florida. That really takes away the ties that he has to this community.
But he'd be staying, I mean, if there's a bond, it's an ankle monitor, it's stay with dad, unless dad lives anywhere near the Van Arsdales, in which case it's don't stay with dad. But it's don't stay down in Florida, it would be stay local.
Right. I understand what you're saying, but I think it creates ties to the area of the country that's easy to flee to and easy to get away from. I would argue that he is a threat to flee. The strength of the evidence makes him a threat to flee, especially considering that if he's convicted, it's a mandatory life sentence. And additionally, I mean, just going through his Instagram, it's replete with drugs and weapons and the selling and exchange of drugs and weapons. Even though he's not charged with that, that goes straight to his, threat to reoffend. He just hasn't gotten caught yet. I think he is a danger. And we would ask that you deny bond.
Is he currently in a no bond status?
Yes, he was indicted at around the 60-day mark of incarceration. So there's no issue of being held prior to being legally entitled to a bond. That being said, we just ask that you deny bonds on the grounds argued. We do believe at least 2 members of his family would like to address the court.
Okay, why don't we do that? Good morning.
Good morning.
Tell me who you are, please, and your connection to Mr. Van Arsdale.
My name is Elisa Van Arsdale, and I'm the mother of Monty Van Arsdale.
Okay.
This situation has completely traumatized my family, my daughters, my husband, and myself. And it is correct that Mr. Marriott has been to my home, which makes it even that much more traumatizing that he was a associate or a friend of my daughters and my son. I am vehemently objecting any bond so that my family does not have to be further traumatized with seeing him amidst the community. They did go to high school together. His father lives within walking distance of my home. And quite frankly, I just feel that with everything that we have had to endure for the 6 months, my son is not here to defend himself. My son also is 19 years old when his life was taken. And I completely object to having Mr. Marriott be amidst the community. His friends, it's too much of a community tie. We've been in the community for over 25 years. Mr. Marriott is, I believe, newly in the community since high school. And we do not want him to receive bond.
Okay.
Because of what has taken place and what has happened. We're suffering traumatically and trying to pull our lives back together, man. I don't see how life can ever be the same without, he was my only son. And just with evil intent, even afterwards, in the comments and the social media and the things that we have had to be exposed to what was said afterwards with no remorse, almost a high level of satisfaction that my son is no longer here, speaks to the character of the individual who I feel, and with what has been told, is the reason why my son is no longer here. So I'm asking the court to please deny bond.
All right. Thank you for being here. Mr. Howell, was there someone else, or did that sort of cover things for the family?
I think we're good.
Okay. I appreciate that input. Mr. Howell, I want to give you the last word as the movement. I know you have zero information about the case, and I get that, but you know a little bit about Mr. Marriott and his situation. So if there's anything you want to add or re-emphasize, I certainly want to hear that.
Just argument about the law and application.
Okay, I'm ready.
You know, the most fundamental premise of our justice system is that a person ought not be punished for a crime until the state demonstrates guilt beyond a reasonable doubt. Unless this right to bail before trial is, you know, preserved by courts across the state, that right to the presumption of innocence would lose all of its meaning. You know, we don't have much information now. Will we be able to deny what the allegation? You know, when looking at reading over Ayala, which I always read over before I go on your motion, even though I've already given it. You know, you talk about the risk of flight, the danger to the community, the risk of committing additional felonies, risk of intimidating witnesses. What I think what we're doing is in reality, we're balancing the equities, the state's interest in protecting the community versus my client's interest in justice. If you read Ayala and the progeny and the other cases that have come out of it, and, you know, cases from other jurisdictions as well, really the amount of bond is what secures the defendant's attendance at trial. The conditions of bond are what protect the community. I believe that there are reasonable conditions that protect the community. The state alleges that the majority of this, you know, their evidence shows that they've been directed and they were done electronically. Well, we ban his use of a cell phone. We can ban his use of a computer. And the court order that he can't contact anybody like that. Risk of flight, that can be alleviated through an ankle monitor in the amount of risk of intimidating witnesses. Again, same thing. Court could order no contact. I believe, given Mr. Marriott's criminal history, which there is none, no convictions, that he's an excellent candidate. The way I like to put it is, I remember the first time I graduated law school and I had zero in trying to go buy a car. Well, you just have to put faith in the borrower that they're going to be able to pay it back. I think Mr. Marriott's lack of criminal history shows that he's a good candidate, and there's faith in him that he's going to pay back by showing up to court and obeying the court orders. Therefore, I believe that the court should set a reasonable bond.
All right. Thank you, Mr. Howe. Mr. Marriott, do you have any questions about anything we've discussed so far?
Yeah, I really do want my discovery pass, sir. That's all.
I didn't say. Oh, discovery packet. Great, because that's where I'm going. So, Mr. Marriott, at this point, I'm going to leave you in a no bond status. I very much understand Mr. Howell's perspective, and I thought carefully about each of the factors. I think your move to Florida is a cause for concern. I appreciate that you've got family here and connections here, but that happened so close on the heels of this situation, whatever your connection to it, that it does make me nervous about making sure you'd be back in court. I also have some concerns about what would happen with people who know about this case and an ability to keep the Van Arsdale family insulated from how you feel about this case and where it might go. And so for now, I'm going to leave you in no bond status. But to your question about discovery, the state will be providing discovery to Mr. Apt in short order. There's a lot of discovery. There are phone dumps. There's this and that. They'll get it all to Mr. Apt. He will get it to you, that which he can get to you. He can't give you a CD with a bunch of pictures on it or text or this or that. He can print stuff out, but he's going to need to arrange for some contact visits with you so you can look at things on the computer. But importantly, I am inviting Mr. Apt, whether it's through Mr. Howe or it's Mr. Apt directly, to ask for reconsideration after he's had a chance to review the discovery and you have as well. There are at least two sides to every story, and I appreciate that I have heard the state's rendition of what happened and who said what to whom and what certain things meant. And sometimes that's exactly what the evidence shows. But other times, once the defendant and his lawyer have a chance to look at the evidence and we get back together, things are shown to me in a different light, and I can be more comfortable that there would be a set of conditions of bond that would ensure you show up, number one, ensure that the community is safe, number two, and ensure that there isn't any risk that you're going to get back in trouble, whatever your cell phone traffic shows. But right now I don't have that comfort level. So we're going to keep you where you are. Mr. Apt will come see you with the discovery and we'll take this back up at the appropriate time. Mr. Hiles, anything else from the state?
No, Your Honor.
Mr. Apt did file a waiver of arraignment, so I know we're in flux with, is there going to be a new indictment? But if you could begin through your paralegal pushing discovery out, that'll address Mr. Marriott's immediate request.
I can do that.
Okay. Mr. Howell, anything else on behalf of Mr. Marriott?
Nothing further.
I appreciate your patience today. Should have been able to do this at 9 and here it is noon. So you spent the morning. I hope Mr. Apt takes care of that for you.
It's part of the job.
Okay. Mr. Marriott, I will see you again once Mr. Apt has gotten that discovery. He will file some other motions, I suspect, and he may well file a motion to reconsider bond. We'll get you here in person so you don't have to be in that booth next time, okay?
Yes, sir.
All right. Thank you, everyone. And thank you, Ms. Alexander, for getting Mr. Marriott into the booth on short notice.
No worries, Judge.
All right. So we're down till 1 o'clock. We'll pick up with our final plea calendar, and we had someone come in late from the morning calendar.